And just one more thing. Just know this. When you can do this, when you become extremely dangerous to their lies, you're essentially setting traps made of their own inconsistencies. And you're doing it while looking like the reasonable adult in the room. That is how you cross-examine and come out looking like the credible up. Handling being cross-examined. Now, staying cool under fire. Now flip the script. It's your turn in the hot seat. And this is where many parents, especially LIPs, litigants in person, get ambushed. The other side's barrister or solicitor is licking their chops, thinking, I'm going to make this person explode or stumble. We won't let that happen here. No. Here's where your psychological armor must be strongest. Your mindset. Being cross-examined is not a personal attack. It's a job. It's a performance. The questions might feel hostile or insulting, but you must internalize that this is a game to them. Their goal is to rattle you, trip you up, or get you to say something that helps their case. Your goal is to deny them that satisfaction, utterly, and no end into it. You do this by adopting a calm, unflappable persona on the strand. Imagine you're a pilot in a storm. On the outside, you project calm, confidence, even if you feel turbulence. Now, key strategies when answering questions. Stay respectful, always stay respectful and composed. No matter what, just stay composed. This is non-negotiable. You address the judge, even the opposing the lawyer, with basic courtesy, your honor, and you give them sir, madam. Yeah. You never roll your eyes. Yeah. Do not scoff or raise your voice. Absolutely do not. Not even in questioning. Even if the question is outrageous, showing aggressive or defiant behavior is a disaster for your credibility. For example, never argue with a judge or lawyer. Never talk over them, and avoid hostile language like glaring or throwing up your hands in frustration. If you do any of these things, the judge will remember, and not fondly. The hard truth here is if you've been accused of being hot-headed or abusive, and then you get angry under cross-examination, you've just proved their case. Fool them. And on the flip side, if you can maintain cool composure while being aggressively questioned, you silently win points. The judge thinks, yes, this person can hold it together under pressure. Maybe the claims of them being unhinged are exaggerated. Take your time. Be precise. Do not rush. Answer the moment a question is thrown at you. You're allowed a brief pause to collect your thoughts. If you didn't catch the question, or it was multi-part and confusing, it's perfectly fine to say, sorry, could you repeat the question? This is much better than guessing or blurting out something that you'll regret. Pausing shows you're thoughtful, not evasive. Answer only what is asked, briefly and directly. This is crucial. Keep your answers short and on point. If you're talking for more than 10 seconds, you're saying too much. It is not your turn to tell your life story or upload your grievances. If the question can be answered with a yes or no, do just that. So many litigants in person fall into the trap of thinking, this is my time to tell my truth. This is my opportunity to get justice. No, this is not your time. That's what your main testimony or statements were for. When being cross-examined, given long-winded explanations or volunteering extra information will usually hurt you. Let me tell you why. 2 reasons. 1, judges are impatient. They have limited time and will get frustrated if you wander off track. Frustrating the person who will decide your case is a terrible, terrible strategy. Number 2, a smart opposing lawyer will let you ramble because they know you might say something inconsistent or revealing that they can jump all over later and use against you. They think if you waffle, go on and on and on like you do, you'll dig your own grave, and they'll often be right. Don't take the bait. If a question needs a bit of an explanation beyond yes or no, keep it to 1 or 2 sentences. If it's longer than 10 seconds, you're saying too much. Then stop. If they want more, they'll ask. Often, giving less is giving them less to twist. Don't fall for the yes-no traps. Sometimes a lawyer will insist you answer yes or no to any specific question. That is simplified or misleading. this is tricky because judges do often expect you to answer the question. Here's how to handle it if this does come up, because it could do. Let's think of a question. Have you stopped doing X bad thing? The classic loaded question. You can respond calmly. I'm sorry, I can't understand that with a simple yes or no because the premise isn't accurate. May I clarify? If the judge allows you to clarify, briefly clarify the truth. If you're cut off, you might have to just stick to your position and say, no, that did not happen. Or no, that characterization is not correct, which at least flags your disagreement. The key is not to be evasive, but also not to be trapped into agreeing something that's false. This is a tightrope, so practice how to deliver a firm but polite answer under pressure. One thing I say is own your shit, stay truthful, admit what you must. I'll be blunt. If you lie or try to bluff your way through, a skilled cross-examiner will nail you to the floor and your entire case will crumble. Because once you're caught in a lie, nothing you say will be trusted. So if there's a tough fact that you have to admit, maybe you did shout at her once, or maybe twice. There was more than one argument. Maybe you did miss a child handover once. Own it with humility. Yes, I did raise my voice during that incident, and I regret it now. Since I've done that, I've taken steps to manage my stress better. I go to anger management classes. A candid admission diffuses the attack. You can't be argued with. It shows you're honest about your flaws. It shows you're self-aware, which actually boosts your credibility. Contrast that with denial that can be disproved. That could lead you to being seen as a liar or even risk perjury. Remember, credibility is everything in family cases. If the judge sees you as generally truthful, they'll forget minor mistakes. If they catch you in a significant porky pie, you're done. Now, know your own evidence cold. Before you step foot into that witness box, make sure you own your own statements. You know what's in them. You study them. Study your statements like evidence. Like your life depends on it, because someone on the other side certainly already has. They will often cross-examine you by referencing what you said in your witness statements or affidavit in your statement. Paragraph 14, you said X, but just now you said Y, which is true. If you don't remember what you wrote, you're in trouble. Inconsistencies between your oral testimony and written evidence will make you look unreliable. So review all of your earlier statements and even texts, emails related to the case. If there is a small error in your statement, you'll get the chance to clarify them at the beginning before you get sworn in, or just as you're sworn in, just as you start your testimony. Some judges let witnesses correct mistakes up front. Better you acknowledge a typo or date mix-up than have the barrister pounce on it and make you look like you're Pinocchio, or deceptive at least. Silent secret here. Now, lawyers bank on you being poorly prepared. Yeah, they love catching a litigant in person off guard. With the litigant's own words, don't give them that satisfaction. If you know your material, you can calmly say, what I meant by X was that there was X, or let me clarify, the date might have been wrong in my statement, but the event did happen. You stay in control of your narrative. Emotional control equals case control. Cross-examination can get intensely personal. You might get accused of terrible things in the questions. They might read your private text of yours in a mocking tone. It can be infuriating. It can be humiliating. But here's your mantra. Do not react. Do not react. At least not with anger or outbursts. Inside, you can be thinking, this is outrageous. But outside, on the surface, you're the picture of calm. Calm. Shui. If you need to take a sip of water or deep breath to center yourself, do it. Because the moment you snap back, how dare you say that, or an emotional rant, you have stepped right into their trap. Instead, respond to nasty questions with factual answers or a simple, calm denial. Example, the opposing counsel sneers, so you enjoy harassing your ex, don't you? It's all a big game to you, isn't it? A reactive person yells, that's a lie. A master of cross-examination, that's going to be you, and you, and you, and you. Calmly says, no, absolutely I don't. I'm here to ensure I can play a part in my child's life I'm not here to play games. Short, controlled, and you've denied their characterization without losing your cool. You come off as reasonable, and the lawyer looks a bit of a fucking idiot. That's a win for you, in the judge's eyes anyway. Play to the judge, not to the lawyer. Remember, while the lawyer is the one asking your questions, your real audience is the judge or magistrates. When you answer, it's often helpful to speak to the judge. Make eye contact with them, not a hostile lawyer, especially if explaining something in detail. You're showing the judge you're sincere and unafraid of scrutiny. Also, psychologically, it takes the power away from the questioner. You're basically saying, I know who ultimately matters here. Just be careful to do it naturally, not in an overly theatrical way. By mastering these techniques, I promise you, you transform cross-examination from a dreaded ordeal into a showcase of your credibility. Think of it as each tough question as an opportunity to prove how solid and calm you are. If the other side throws curveballs, you sidestep that shit with poise. If they try to bully, you remain unshaken, which often makes the bully look bad. This drives professionals crazy. Crazy! By the way, just proper crazy. A litigant person who does not take the bait because it neutralizes one of their biggest advantages. Your fear and inexperience are landmines. What not to do. These common mistakes. Now that you know the do's, let's look and hit out the don'ts, the fatal mistakes that can undermine your hard work. Consider these as landmines scattered across the cross-examination field. Step on 1, boom, your credibility is blown. We're going to identify them so you can walk around them safely. Don't turn into a pit bull. This applies when you're the one asking the questions. Do not get aggressive or argumentative with the witness. Yes, you might be furious at your ex's lies, but cross-examination is not the time to vent anger. If you raise your voice or use a harsh tone or badger the witness, you will look like you're the antagonist. And in the story, that doesn't look good for you. The judge will immediately think you're more interested in fighting your ex rather than focusing on the child. Remember, aggression equals instability. In the eyes of the court, you don't want to be unstable. You don't want to be thought of as being you don't want to be the one carrying that feeling of you're not able to care for your kids. No way. So instability. Keep your voice measured. Your demeanor businesslike. Every question should come off as reasonable and fair. If the witness is evading the question, you can press firmly, but never with insults or shouting. Don't make personal attacks or accusations. Calling the witness a liar or making snide comments is a huge no-no. Not only will it anger the judge, it gives the other side moral high ground. Attack the facts, not the person. The facts. For instance, instead of she's completely lying about that, ask a question that demonstrates the lie. You're being cross-examined and the lawyer is goading you by attacking you. Don't take the bait and attack back. Stick to answering the questions. Personal score settling can wait for another day. Preferably never in court. Never in court. Don't ramble or volunteer extra information. Whether you're asking or answering, avoid wordiness. If you're cross-examining, don't preface your question with a mini speech. Just ask it. And if you're answering, don't start telling a story. Unprompted, long, rambling discourse hurts you. It either puts everyone to sleep, and you don't want them sleeping, frustrates the judge, and you definitely don't want a frustrated judge, and it leaves the doors open for the opposing side to pounce on any inconsistencies. One question, one answer. No unsolicited tangents. And don't dodge the questions. You must answer. If you're being asked something legitimate, answer it. Trying to evade a fair question makes you look shifty, and the lawyer will just pin you down harder. If you truly don't know or recall, it's okay. Say, I don't recall, I don't remember. But if you clearly sound like, you should something you should know, like where you were living in 2021, don't pretend ignorance. Answer directly, then stop. Remember, a pattern of non-answers will irritate the judge and prolong pain for you. And we don't want to irritate the judge. Judge does not want to be irritated. Don't argue with the opposing side, counsel, or the judge. This sounds obvious, and it is obvious. But in the heat of the moment, many litigants fall into the trap of, shouting and arguing. If the judge tells you to move on, move on. He's saying it for a reason. If the judge sustains the lawyer's objection to your question, don't argue it. But I'm just trying to, no, save it. Arguing with the judge is practically suicide for your case. You don't want to be hanging yourself yet. And if the opposing lawyer is being snide, don't snide back. You can politely assert yourself if needed. Counsel, please. Let me finish my answer. If they keep cutting you off, but never in a combative way, keep it professional at all times, professional, super professional, businesslike. Don't interrupt. Let the other person finish what they're saying, whether it's the witness answering or the lawyer questioning. Cutting someone off, even if they're spewing nonsense, makes you look like you're out of control. If you're the witness and the lawyer is badgering you on without letting you finish your sentences, answer like that. Look to the judge. Look to the judge and say for help. The judge should intervene. If not, you might say something like, "I'd like to finish my answer," but do it. Do not get into a shouting match of interruptions. That's chaos. That's just pure chaos, and only makes you look bad. Makes both of you look bad. And guess who the judge is going to more likely blame? Guess. You. The self-rep. Unfortunately, don't forget to prepare. Winging it is a mistake. Going at cross-examination without being prepared, without prepared questions, or without having rehearsed tough questions you might face is like going into a boxing ring with your hands down against Mike Tyson. That'd be stupid. You will get knocked out straight cold. Preparation is your friend. It gives you confidence and a game plan, so you're not reacting on pure adrenaline. Use the tools and techniques we've covered. Write down your key questions in advance. Practice answering awkward questions calmly. Maybe have a friend or grill you, or use one of our tools in Find a Mackenzie Friend Near Me to simulate questions. The more you practice, the less likely you are to freeze or to ramble when it counts. Don't contradict yourself, even without explanation. Even if at one point you realize you said something different, address it briefly. For example, if evidence shows you earlier agreed to something, but now you're saying that the opposite, you're saying the opposite, acknowledge it. I see that in my early email, I said it was fine. I was fine with that arrangement at the time. I was trying to keep the peace, but it wasn't truly workable. If you just outright deny something that is clearly in evidence, you'll be seen as either stupid, forgetful, or dishonest. We don't want either of them, do we? Consistency is key. And if you must change a previous stance, do it with a sensible reason, not just because you want to. Otherwise, inconsistency will be used against you to brand you as unreliable, avoidant, facetious. Avoiding these mistakes is as important as doing the right things. One slip, one moment of anger, one careless word can spring a trap that's hard to recover from. Speaking of traps, let's talk about those next. Traps of the professionals. They set them up all the time, and how to subvert them. This is what we're going to tell you, how to get around them. Make no mistake, the opposing barrister, solicitor, has strategies of their own. They've likely been doing this for years, refining it, ways to trip up witnesses and LIPs. But today, we're going to expose their common traps, so you can see them coming. Even Stevie Wonder could see them coming, and you can turn them into your advantage. The friendly setup. Now, sometimes, in fact, a lot of the times, a lawyer will start by cross-examining you with an extremely friendly or casual tone, lulling you in to a drop in your guard. They might smile, ask a few harmless questions, or 2 or 3 harmless questions, make it seem like you're a reasonable guy or girl, trap you in to start relaxing. Maybe you start getting chatty too much or too comfortable. Then comes the zinger. They hit you with a tough or loaded question when you're right off guard. How to counter this? Don't buy into it. Just don't buy into it. Stay alert and businesslike, no matter how nice or informal the opposing lawyer appears. Treat every question seriously. If they joke, you can politely smile, but keep it minimal. Your answers tight, really tight, very tight. Remember, they are not your friend. The real game is still to undermine you. The loaded question. Now, this is a classic trap. Have you stopped doing blah, 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 whatever you were doing that was bad? Or any question that assumes something damaging. For example, why did you think it was okay to ignore the court order? The assumption is you did ignore it. If you answer directly, you're implicitly confirming their narrative. So how to counter this? Do not accept the false premise. You can respond, I disagree with the premise of that question. I'd comply with the order as best I could, or I didn't say I thought it was okay. I explained the circumstances. Essentially, you reframe the question in your answer. You're not dodging it, you're correcting it. It takes presence of mind, but it's crucial acknowledging questions only to refute its assumption calmly. If you simply say, I didn't ignore it, that's fine. It's fine too. It's perfectly fine. The key is you don't get trapped into saying it because which would accept their framing, the yes no pin down. We touched on this a moment ago. They will often demand a simple yes or no on a complex question. It's a trap, obviously. If you say yes, it might misrepresent you. If you say no, same issue, might misrepresent you. And if you try to explain, they may cut you off and push you to the side. Just say yes or no, making you look really evasive. How to counter this? Stand your ground politely. It's not a yes or no question. I'm afraid I need to clarify. If the judge tells you to answer yes or no, then you might say, then no, with respect, because the question isn't fully accurate. Show that you're not refusing to answer, you're refusing to answer unfairly. A good judge will allow you a sentence or two to clarify after the yes or no if needed. If you get streamlined or streamrolled, whatever you want to call it, don't worry. You can later clarify in a re-examination or even in a closing statement if you're the litigant person, though usually you can't testify in a closing, but you can point out what's gone wrong. Opposing counsel's yes or no questions oversimplified the issue. If you're summarising a LIP, the main tactic is don't get flustered. They want you to look like you're hiding something. Instead, you look like you're trying to be accurate with which reads honest. The waffle rope. When you're cross-examining them, be aware the trap of a witness rambling. Sometimes you'll ask a question and the witness goes off onto a tangent or starts giving long narrative. If the witness is the other party, they might use this to get sympathy or sneak in the other side of the story. Or if it's an expert, they might drown you in jargon. The trap, you lose control of the cross-examination and valuable time and potentially the judge's attention as the witness steers off course. How to counter? Politely interrupt with focus. Thank you, but I'm going to stop you there. My question was actually simpler. Or appreciate the context, but could you please just answer my specific question? Repeat that if you have to. You have the right to be responsive. If they still won't, you can ask the judge to direct the witness to answer the questions asked. The judge might step in if the witness filibusters, flaps around. The point is, don't let them run the clock down or bury the issue in the words. By keeping control, by sticking to your prepared questions, and by cutting off the irrelevances. Silence as a weapon. This is the reverse trap. Earlier we talked about this. You talked about you using silence. Well, solicitors, lawyers, barristers might use it on you too. For example, they ask a question, you answer it, and then they pause and stare at you, straight at you. Most people feel the urge to fill that silence, often by nervously rambling or adding more detail, which can lead to trouble. The trap is you blurt out something you shouldn't or weaken your answer by over-explaining. Now, how to counter this? Once you've answered succinctly, stop talking. Let them be the one to break the silence. If they want more, they can ask for more. It's that simple. Resist the urge to babble. Because just because it's quiet, that shows confidence. It's absolutely fine to be in cross-examination that there is pauses. You're under no obligation to chatter. Let the lawyers or solicitors fish. If you've given your answer to everything, just wait calmly. Provocation and emotional triggers. Good solicitors and lawyers do their homework on you personally. They might know exactly what topics make you upset or words offend you. For instance, they may throw you in a snide comment. You've always been more about hurting your ex than helping your kids, isn't it true? Not because they expect you to agree, but because they hope you'll explode. and indignation. They're hoping you'll explode in indignation. The trap is not to react to anything that you shouldn't have to react. Right. So lawyers' questions that feels like personal attack, mentally, label it. They've been trying to push my buttons, then flip it. Respond as if it didn't faze you. Get someone else to respond for you. Get a ghostwriter. There's someone, find MackenzieFriend.com and find Mackenzie Friend UK. I'm sure there is, actually. I'm sure there is. So you can get a decent one there. Probably better than, and better value than the court-approved one at this stage as well. Because all you're doing is getting tests, but yeah, we'll get that sorted. Then respond as if nothing phases you. So something like, absolutely not. My focus has always been on my children's well-being, said firmly, but without anger, and that shuts everything down. No matter how unfair the institution is, by responding with calm defiance, you come across as the credible one and the more composed and one with common sense. They lose that round, letting you waffle. It bears repeating from the earlier session because it's definitely a conscious tactic from pros. If you start giving an unhelpful, long-winded answer, sharp cross-examiner will sit back and let you. They won't interrupt you. They might even nod occasionally. Why? Why? Because you're likely hurting your own case. Remember, you reveal inconsistencies or you say something that opens a new line of attack. Trap your own words because they become ammunition against you. How to counter? Catch yourself. If you realize you're rambling, stop. There's no rule that says, I have to have a pause here. Let me just stop. To sum up, this is gold. Watch it again and watch it again if you need to. You don't have to fill every second with talking. In fact, concise answers give opposing counsel less to latch onto. Less chance to turn your fact into fiction. If they're not intervening, it might not mean you're doing great. It might mean you're walking onto a trap. Stick to the questions asked. Be quiet, force them into work for it. That's what you need to do, force them to work for it. By anticipating these traps, not only will you avoid stumbling, you can sometimes turn them into your advantage. Each trap sidestepped into a small victory for you, frustrating the opposition. Imagine their plan was to get you angry and you stayed cool. They'd be spitting feathers. They got nothing on you. Or they hoped you'd volunteer some damaging information and you didn't. You don't. And they're stuck. This flips the power dynamic. You become the one in control of the narrative. Now, mastering cross-examination is not easy. This game, cross-examination, is often described as an art form. But today, we're breaking it down into science and strategy. The big secrets is that the legal insiders never want you to know, right? And I can tell you, you can be just as effective in cross-examination as a seasoned lawyer if you followed this approach. With the right mindset and preparation, you have this knowledge. You now know that family court cross-examination isn't about yells, who yells the loudest, or who catches someone in Perry Mason moment. It's about who remains composed, credible, and compelling under pressure. Is the final hard truth. If you've followed along to day 17, you're not the average litigant in person anymore. You're being equipped with the tools and insights that tip the balance in your favor. But tools only work if you use them. So your call to action today is to practice and embody these techniques. Knowledge alone is nothing without execution. Take the questions you prepared for and rehearse them out loud in a calm, inquisitive tone. Enlist a friend or use a family member. Support tools on Find a Mackenzie Friend near me should be able to help. We provided to simulate a cross-examination scenario. So yes, literally, we have someone on standby 24/7 to do that for you and with you, to pretend that they're to be your ex, the lawyer, and throw back the questions at you. Practice answering calmly, no matter how provocative the question is. Use the strategic prep system at your disposal, the same ones we've been given you throughout this 30-day program. To refine your questions and answers, if there's a particular trap you're worried about, work through it. Now, in practice, until you feel comfortable, you can do it and handle it in court. Self-mastery is the name of the game. It's not just about outsmarting the other side. It's about mastering your own reactions, fears, and impulses. When you can walk into that courtroom knowing, I am prepared, I am calm, and I know exactly what my points are. you become incredibly powerful. Judges sense it. Opposing lawyers sense it. You project the energy of someone who cannot be easily rattled or tricked. That is often enough to tilt the case in your favor. As we wrap up day 17, visualize this. The courtroom, the opposing counsel, ready to fire questions. Your ex perhaps putting on their act. And there's you. There you are. Steady, unafraid, and in control. You ask your questions with surgical precision, and you answer theirs with unwavering poise. Every trap they've set falls apart, falls down. Every lie they tell, you expose with calm evidence. You change the narrative from angry parent versus victim to reasonable parent versus story just full of holes. This is how you win in family court, by demonstrating through your cross-examination conduct that you are the credible, child-focused adult in the room. Make a commitment right now, to apply to these lessons tonight. Run through the mock questions and exam scenarios, and using the framework we've discussed. Or use the AI tools and find a Mackenzie friend near me. That will give you realistic practice. And then there's nothing stopping you.